How does GDPR address data transfer outside the European Union, particularly to countries not recognized as providing an adequate level of data protection? A. Data transfers are unrestricted, as GDPR applies globally to all organizations processing data of EU residents. B. Transfers are permitted only if the receiving country has been formally recognized by the EU as having adequate data protection laws. C. Transfers can occur if appropriate safeguards are in place, such as binding corporate rules, BCRs, or standard contractual clauses, SCCs, or if specific conditions are met. D. Organizations must obtain explicit consent from each data subject before transferring their data outside the EU, regardless of the receiving country's data protection level. Correct answer, C. Explanation: GDPR places strict conditions on the transfer of personal data outside the EU, especially to countries not deemed by the European Commission to provide an adequate level of data protection. Such transfers are allowed if appropriate safeguards are provided by the data exporter, including binding corporate rules for transfers within a corporate group, standard contractual clauses for transfers between companies, or specific exceptions apply, such as explicit consent from the data subject for the proposed transfer after being informed of the possible risks. What is the primary role of data protection impact assessments, DPIAs, under GDPR? A. To ensure all data processing activities have the necessary legal paperwork. B. To assess the risk levels of data processing activities to the rights and freedoms of natural persons. C. To calculate the financial impact of data breaches for an organization. D. To provide a yearly audit of an organization's data processing activities for regulatory bodies. Correct answer, B. Explanation: data protection impact assessments, DPIAs, are a crucial tool under GDPR designed to help organizations identify, assess, and mitigate the risks associated with data processing activities, especially those that pose high risks to the rights and freedoms of individuals. DPIAs are proactive measures that ensure data processing is conducted safely and in compliance with GDPR, emphasizing the protection of personal data from the outset. Under GDPR, what constitutes a lawful basis for processing personal data? A. The individual's consent and the organization's need to process data for operational purposes. B. The processing is necessary for compliance with a legal obligation to protect the vital interests of the data subject or another person for the performance of a task carried out in the public interest or in exercising official authority vested in the controller. C. Any situation where the data subject is unable to provide consent due to age or incapacity. D. Processing based solely on the organization's financial interest. Correct answer, B. Explanation: GDPR specifies several lawful bases for processing personal data, ensuring that such activities are justified and transparent. These include consent, contractual necessity, compliance with legal obligations, protection of vital interests, tasks carried out in the public interest or exercise of official authority, and legitimate interests pursued by the data controller or a third party, provided these interests do not override the fundamental rights and freedoms of the data subject. Which of the following best describes the right to be forgotten under GDPR? A. Data subjects have the right to have their data erased if it's no longer necessary for the purpose it was collected. B. Data subjects can request deletion of their data for any reason, without providing justification. C. Organizations must automatically erase personal data after a set period, regardless of the data subject's wishes. D. This right allows data subjects to erase their digital footprint entirely from the internet. Correct answer, A. Explanation: the right to be forgotten, also known as the right to erasure, entitles individuals to have their personal data deleted by the data controller under specific circumstances. These include situations where the data is no longer necessary for the purpose it was originally collected or processed, the individual withdraws consent, or there's no legitimate ground for the processing. This right is not absolute and must be balanced against other rights and obligations. How does GDPR define sensitive personal data, and what additional protections are afforded to it? A. All personal data is considered sensitive under GDPR, receiving the highest level of protection. B. Sensitive personal data includes details about an individual's financial status, receiving additional encryption. C. Sensitive personal data encompasses special categories of data such as racial or ethnic origin, political opinions, religious beliefs, genetic and biometric data, where processing requires stricter conditions. D. Sensitive personal data is any information that can be used to directly or indirectly identify a person, requiring user consent for processing. Correct answer, C. Explanation: GDPR identifies sensitive personal data as special categories of personal data that reveal racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data for uniquely identifying a natural person, data concerning health, or data concerning a natural person's sex life or sexual orientation. This type of data is subject to additional protections, and its processing is generally prohibited unless specific conditions are met, such as explicit consent or necessity for the protection of vital interests. What implications does the GDPR have for the use of automated decision-making processes, including profiling? A. GDPR categorically prohibits all forms of automated decision-making and profiling. B. Individuals have the right not to be subject to a decision based solely on automated processing, including profiling, if the decision produces legal effects concerning them or similarly significantly affects them, except under specific conditions. C. Automated decision-making is permitted without restrictions, provided that it is part of a contractual agreement with the data subject. D. Organizations can use automated decision-making freely, but must disclose the logic involved and the significance and envisaged consequences of such processing to data subjects. Correct answer, B. Explanation: GDPR provides individuals with the right not to be subject to decisions based solely on automated processing, including profiling, that have a legal or similarly significant effect on them. Exceptions exist, such as when automated decision-making is necessary for entering into or performing a contract, authorized by EU or member state law, or based on the individual's explicit consent. In these cases, organizations must implement suitable measures to safeguard the data subject's rights and freedoms and legitimate interests. What obligations does GDPR place on organizations regarding data breaches? A. Organizations must notify the relevant supervisory authority within 72 hours of becoming aware of a data breach, unless the breach is unlikely to result in a risk to the rights and freedoms of natural persons. B. Organizations are required to notify the public within 24 hours of any data breach, regardless of the breach's severity. C. Data breaches only need to be reported if they involve sensitive personal data. GDPR requires organizations to report data breaches only if requested by data subjects. Correct answer, A. Explanation: GDPR imposes strict requirements on organizations to report data breaches. Organizations must notify the relevant supervisory authority within 72 hours of becoming aware of a breach, provided the breach is likely to result in a risk to the rights and freedoms of natural persons. This rapid response is critical to managing the breach effectively and minimizing potential harm. In cases where the breach poses a high risk to individuals, the organization must also inform those affected without undue delay.